Law Before Lunch, a creature of the pandemic. It's all to do with reaching out to people around the world. We've got a global audience, I can see, which is great. As you can tell by muting myself, I haven't done a webinar in ages. I've actually forgotten how quickly to take these jellyfish off the background. But since I'll be sharing my slides very soon, I won't bother about that, fuss about that now. Law Before Lunch, it's all about trying to get some important points across to you in 20 minutes or less. We're all busy people. We don't want to spend time listening to great rambling long webinars. Who am I? I am Richard Stevens, together with my consultant, Oscar Rowlands. I am the Law Office of Richard Stevens, specializing in IT contracts. If you like what you see today, I also provide training on commercial law subjects. If you're a litigator out there, and I can see that some of you are, but I also work as a mediator in the IT sector. I also accept references as an arbitrator as well. I actually just signed off an award on an international loan agreement not so long ago. But today, I'm going to be looking at liquidated damages. Not so long ago, there weren't that many cases coming through on liquidated damages. Now they're coming through at a rate of knots, and they are law, contract drafting, changing things. So what I wanted to do was actually take a look at some recent cases and focus on them and see how they should change our drafting. So I'm going to share my slides with you now. So you should now see my slides. Law Before Lunch, penalties, aka liquidated damages, aka LDs. I know there are some non-lawyers out there, so non-lawyers tend to call these things penalties. Just so you're aware, when the law calls something a penalty, it means it's unenforceable. I'm going to come back to that in just a little bit later on. Lawyers call these things liquidated damages, or LDs for short. There is some recent cases, very important stuff. Triple Point and PTT. The first case in years to go to the Supreme Court on liabilities, dealing fairly and squarely with liabilities. So it generated a huge amount of interest. Moreover, the Court of Appeal decision on liquidated damages was widely assumed to have been a complete horlicks and to have wrecked a lot of the drafting of LD's provisions. So all eyes were on the Supreme Court. The basic facts, we don't need to spend too much time on. This was a software contract. PTT was a commodities trader based out of Bangkok. Triple Point was a software developer. It had a trading platform software package, and the contract was for it to customize that and to implement that for PTT. The Supreme Court made much of a lot of the provisions and cited them at length. As a seasoned IT lawyer, I can tell you, I didn't see anything that looked unusual from what I saw. The project got off to a start, but then it quickly met snags, delays, problems, and PTT terminated the contract. They never accepted anything. Nothing had been formally delivered and accepted. That's important because this is the clause. Have a look through it, and I'll keep talking as you have a quick gander through it. It's actually a fairly typical sort of LD's provision. I've underlined, as I always do, the key words. So we're talking about LD's payable per day of delay from the due date for delivery up to the date PTT accepts such work. And it was these words that threw the Court of Appeal. They latched onto those words and they said, well, as PTT never accepted any work, therefore, the liquidated damages provision on its terms never comes into effect. So no, LDs could be payable. This caused consternation in the drafting community. And it was a result that came from absolutely nowhere, from left of field, if anything. So the question is whether that was right. So issue one in the case of the Supreme Court was, are LDs payable where work is never actually completed? They started off by saying that LDs are a good thing. As one of the judges said, parties agree an LD's clause so as to provide a remedy that is predictable and certain for a particular event. Here, as often, that event is a delay in completion. The employer, customer, does not then have to quantify its loss, which may be difficult and time-consuming for it to do. So LDs are a good thing in the eyes of the law, but they laid down the traditional law in this area. LDs accrue according to the terms of the contract, and they accrue from day to day right up to the point of termination, after which the claimant is entitled to prove any general damages it's able to show. You don't have, they said, to provide for what happens on termination, contrary to what came out of the Court of Appeal. You don't have to deal with a failure to complete. The drafting points are, of course, obvious. It will do you no harm to specify exactly what you mean in these two circumstances. It does do you no harm to say that LDs are payable whether you complete the project or whether you don't. It doesn't do any harm to say that they're payable up to the point of termination, and thereafter the claimant can claim general damages, such damages as it is able to prove. It does you no harm, but strictly speaking, you don't have to do that. Issue 3, and the astute amongst you will have noticed that I've missed out issue 2. Issue 2 is an absolute corker. It's not strictly to do with liquidated damages. If I've got time, I will come back to that at the end. It is a liabilities drafting changing point. It's an absolute corker. My jaw dropped as I read the majority's judgment on that point. As I say, if I've got time, I'll come back to that at the end. Let's get to let's stick to LDs, and let's look at issue 3. This slide raises the question of what happens, what's the relationship between an LDs clause and any caps of liability typically contained in the clause dealing with limits and exclusions of liability. What's the relationship between the two? Take a look at the second sentence here. The total liability of triple point to PTT under the contract shall be limited to the contract price received by triple point. As a fairly standard sort of clause you see in IT contracts. But the question is this: if you've got an LDs provision here and you've got a cap on liability there, is the LDs provision like a separate pot, separate from the other cap, such that the LDs provision is available on top of the other cap? Interesting question, and it comes down, as the Supreme Court observed, to being a straightforward point of construction. And they said, you just look at the wording here, look at the words on a page. It says here, total liability of triple point shall be limited to the contract price. And that means it's total liability. And that includes damages for delay, liquidated damages, damages for defects, damages for any other breaches whatsoever. So it's not a separate pot. It's subsumed within the general cap on liability according to this wording. Of course, different wording could have a different result. What about this third sentence of Article 12.3? Except for the specific remedies expressly identified as such in this contract. Aha, said the Supreme Court, that must be referring to liquidated damages. So this clause doesn't apply to liquidated damages. Have a quick look at it. PTT's exclusive remedy for any claim arising out of this contract will be for triple point on written notice to use best endeavours to cure the breach, or failing that, to return the fees paid to triple point. So, said the Supreme Court, this relates not as a total cap on liability. This is an individual cap on individual breaches, but not breaches involving delay. That's the only thing. As I say, there have been a number of cases coming out on LDs, and this is another one. I won't say the full name, I'll just call them Eco World against Dobler. Dobler was a German business. It was doing facade work on a building site. There were blocks A, B, and C that it was doing the facade work on. They were seriously in delay. Eco World was entitled under the contract to take over any particular items of work it was dissatisfied with, and so it would take them away from Dobler to complete. It elected, according to the terms of the contract, to take over blocks B and C, leaving Dobler with only block A to complete. The contract had an LDs provision. Now, have a quick gander through it. I'll keep talking. I've underlined the important bits. What I'd like to see you do, actually, if you are drafting LDs on behalf of the potential recipient of LDs, what word has been used in the first paragraph that you shouldn't really be using? It's a concept that also comes up in the second and third paragraphs. What word, what concept should you not be using? Pop it in the chat if you can spot what that is. It actually came up in this case, and it's an important drafting point. Just for the non-lawyers there, I mentioned this distinction between a penalty and liquidated damages. Another Supreme Court case back in 2015 was the Carringer Square and Macdessie case, and that dealt with penalties straight on, heads on. It was a long and confusing judgment, and at the risk of a gross overgeneralization, what it said was this: if you draft a contractual remedy for a breach of contract, and that can be for like a deposit, a forfeiture of a deposit, forfeiture of shares, liquidated damages, service credits, whatever that may be, if you draft a specified contractual remedy for a particular breach of contract, if that remedy is so extortionate, so extravagant, so unconscionable, that it's out of all proportion to the legitimate interest of the innocent party in enforcing, the court can declare that remedy a penalty, and a penalty is unenforceable. That's the important thing, and that's why you shouldn't really use the term penalties. The court will always look at the substance of the thing, not at the wording. So it doesn't really matter at the end of the day what you call it, but it's best to be consistent. And if you look at this clause, and I hope you've had a chance just to have a quick gander through it, it provides for liquidated damages, and another part of the contract actually specified the contractual rate of LDs that were payable. But you would expect it to say, well, if blocks B and C are taken away from Dobler, then the liquidated damages go down to a third of their rate, because Dobler's now only got block A to complete. But it doesn't actually say that, it doesn't mention it at all. So the first question is, does that mean that the LD's provision is void or has become unenforceable for lack of certainty or incoherence? And so that was the first issue for the judge to look at. And she said that the starting point is obviously to construe the contract. There are cases on this very issue going both ways. And she said, just looking at the wording as it existed on a page, true it was that the LD's provision didn't make didn't provide a wording to deal with this particular situation, but it didn't render it unenforceable or unworkable as such. So it stood in place. It was therefore workable. The next question, of course, is, well, was it therefore a penalty? Was it therefore a penalty? Remember, if you specified liquidated damages based on the fact that you're dealing with blocks A, B, and C, if you're paying the same rate of liquidated damages, but you're only working on block A, does that mean it's become a penalty? Has it become extravagant, extortionate, unconscionable? And the judge picked her way through this, and I set out on that slide the sort of factors that judges typically say in this case. The basic rule is that the judges follow a hands-off approach. And where you've got a commercial contract, their attitude is to say, these are big boys and girls, they're capable of reading their own contract, they're capable of getting their own lawyers to advise them, and we, the judges, will not intervene and declare bits of their contracts unenforceable or illegal unless we're really forced to do that. And so the factors I set out on those bullet points are the factors that the judge considered in this case, and basically she came to the conclusion that this wasn't a penalty. The next point is this, discretion, and Rebecca Riding, you got it absolutely spot on right. If you're, the drafting point is this: if you are drafting for the potential recipient of liquidated damages, you should be using the language of entitlement, not discretion. And what the clause said was, if you remember, it said, in the event of delay, EcoWorld may issue a notice requiring liquidated damages. No, you write the clause saying EcoWorld shall be entitled to liquidated damages at the rate set out in blah, 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 blah. As soon as you use words like may, you're potentially introducing the language of discretion. That's also backed up because in the two little subparagraphs, it then said that it could claim, it may claim liquidated damages at the rate stated in the trade contract particulars or at a lesser rate stated in the notice. Aha, said Dobler. That means there must be an implied term to the effect that you must take account of the fact that you've taken away blocks B and C. We're only left with block A. So you should exercise that discretion only to charge us for, I don't know, 1/3 of the contractual rate of liquidated damages. There's been some law on this, and for those of you who are fans of my annual contract law update, of which more are on, there's been quite a lot of law on this in recent history. This whole area of discretions has gone out of control. But some cases in particular have looked at service credits and their relationship to discretion. And the judge cited the Mid-Essex Hospital and Compass Group case. She didn't cite the rather more interesting case of Portsmouth and Ensign. Now, that was a case dealing with service credits where the claimant had a right to claim within a range of service credits. And the judge in that case said, well, that does import discretionary law, and therefore you can't just charge the full maximum whack of service credits every single time. So be very careful. The drafting point is obvious. If you're drafting for the potential recipient of liquidated damages, it's as simple as saying, my client shall be entitled to liquidated damages at the rate of, and don't, you may not, of course, you may decide for any reason not to charge them or not to charge the full whack, but that's different. But that's a very different question. Don't use this language of discretion. On the other hand, of course, if you're drafting for the potential payer of LDs, try and bring in the language of discretion and good faith and everything else that you can think of, because it may give you an argument to get out of it. In this particular case, the judge said, I don't think this is a discretion. I think it's an absolute entitlement. She didn't cite the case of Portsmouth and Ensign. I'm not so sure, but then again, I'm not a judge. She is, so her decision is obviously the right one. I'm going to skip a few slides, and actually, because I'm conscious of time, and I'm going to go to this point 2. If you remember, I talked about triple point, which had point 2, and I said it was a corker. You will not draft liability provisions again in the same way about this one point. I talked about Article 12.3. It had a number of provisions to do with caps on liability. And this was the final sentence. This limit of liability, so it contained all those little caps that were contained in Article 12.3. This limit of liability shall not apply to triple points liability resulting from negligence. Negligence. Okay, so the question then is, what is negligence? And there are at least 3 different contenders for this honourable role. Negligence could be, the first one is, it could be this independent tort of negligence. So if I accidentally and carelessly burn down your office, if I negligently drive my car and run you over and cause you personal injury, that's an independent tort of negligence. But negligence could also mean a breach of the duty, of a contractual duty, to take reasonable care and skill. The third option, of course, is that the simple word negligence could refer to both of those things. Now think about it. If negligence includes a breach of the duty to take reasonable care and skill, think of that contract that Triple Point had and all the duties of care that it had to PTT. If all of them could be categorized as negligence, then Triple Point would be facing unlimited liability for all those individual breaches of that contractual duty to take reasonable care and skill. This one, the other two issues didn't, but this issue split the court, and by a bare majority, 3-2, the judges said that negligence meant not only the independent duty, this tortious duty, but it also meant a breach of the duty, of the contractual duty to take reasonable care and skill. As the minority said, this drove a coach and horses through the liability scheme, which the parties had obviously tried to set up in Article 12.3, because all you needed to do was then reformulate your claim as a numerous breaches of a duty to take reasonable care and skill and a failure to do so, and Triple Point would be facing unlimited liability for that. I see the word negligence. It's a question of construction in each case, as the majority said, and this is the construction they gave that word in this particular context. Your mileage may vary. But where you're using the word negligence in a liabilities provision, just be aware that it could mean one of three different things, and you need to specify which of those three things you actually mean, because it could mean something fairly different. That's all I was going to say today. If you liked it, well, you can buy me a coffee, and that's great if you do. It's not obligatory. It takes longer to put together a short talk than it does a long one. Put in your diary the annual update I do on contract update on contract law. That's coming on the 8th and 15th of February. You can just Google for it, SCL annual update on contract law 2022, and you'll get to the registration page. If you ask for a copy of my slides, I'm very happy to share those with you, and you can click through on the link. We had nearly 300 people from around the world online last time, so be there or be square. Mark has asked a question: is there any difference between negligence and gross negligence? Yes, there is. The gross negligence doesn't actually occur as a concept in English law. There was actually a case on that fairly recently, a decision of Justice Foxton to do with a property development case. I'm trying desperately to think of its name. I have forgotten its name. I'm probably going to be dealing with that case at the update on contract law. So yes, it doesn't exist as a concept in English law. It exists as a concept in various continental civil law systems. But where the judges see gross negligence, they do see it as something a bit more serious than just negligence. If there are any more questions, very happy to take them. Otherwise, you're probably munching your sandwiches. But we've got people from around the world, so you could be munching your breakfast or your dinner or your high tea, whatever it may be. LDs is sort of quite a sleepy little area, really. And one of the fun things about doing this job is I sort of get to read all the contract law cases as they come out, all of them, but the big ones. And I sort of see themes coming out. And I remember saying when the MacDessie case came out, I said, this is going to lead to a welter of litigation about what penalties are. And I was actually right on that one. There are lots of other cases which I'll be dealing with in the SCL update to do with penalties. By and large, the courts take a hands-off approach to that, but there have been a few exceptions to that recently. And it looks like the courts may be going a bit soft on that issue. But if you're interested, you can come to the annual update, or of course you can ask me to come and speak to you about it as part of the training course I offer, and let me know. Any more questions for that? Any more burning points? Anybody use the word negligence in their drafting of liabilities provisions? I have to say my jaw dropped and my eyes opened wide, because one of the things the majority said was any solicitor knows that negligence will refer to not only the independent tort of negligence, but it's also this breach of a contractual duty to take reasonable care. As a solicitor, technically, I know that, of course I do. I have to say, when I see the word negligence used in the context of liabilities, I personally think of the independent tort of negligence. I think it's what the parties really mean. But it's another one to be very careful about when you're drafting. I say it's one of those jaw-dropping moments. There aren't many when you read sort of long law reports, but it's one of them. It's one of them. Any more questions? Nobody asking any more questions? Everybody munching their lunch, breakfast, dinner, whatever it may be. I gave you a few more minutes. I keep the line open for a few minutes or two, just in case anybody's got questions. But people sort of I think leaving the room. So if you've got no more questions, someone could tell me how to take this jellyfish background off. That would be great. Choose virtual background. That's it. There we are. Let's go to. Actually, I can't find where it is. There we are. That's my study. That's my study downstairs. I'm actually upstairs at the moment at home. Would the solution be, say specifically, Connor? Yes, absolutely. You need to define exactly what you mean by negligence, and you need to say it's the duty in tort. It's the independent tortious duty, as you have said there, to exclude that concept of the contractual duty to take reasonable care, to exercise reasonable care and skill. So absolutely spot on right. It's not something I was astonished, as I say, as a solicitor. I obviously know what negligence means, and I know it does technically refer to both of those things. I think most solicitors use negligence in the term of the independent tort. It's another thing we now need to define in the contract. The two dissenting voices in the Supreme Court were pretty scathing of the majority's decision. However, they were in the minority, so that's basically where we are. It's a point of construction, and of course, your mileage may vary, and it may be that in a different case, a court is entitled to come to a different conclusion. It's not an absolute rule, but it's just now as well to be aware of it. Question, trainee question. If LDs are specified, does this negate any other claim for that issue? Yes, liquidated damages. In Scotland, I think they call them liquidated damages. Liquidated damages are damages which are liquidated. And that means it's an old-fashioned way of saying fixed. Those damages are fixed at that level. So for that level, so for the breach that falls within the liquidated damages clause, those damages are fixed at that level. Of course, if there are other losses that have been covered, which incurred, which fall outside the scope of the LD's provision, then they could be claimed as general damages subject to any cap. But that's basically what it means. But again, as a drafting point, it does no harm to make that clear. Some people have a rather odd idea about penalties, and they think it's like a windfall, and they can get that on top of any other things that they want to claim. And that's why when you're drafting service credits, which are generally much lower than liquidated damages, and that's why it's common to put in a bit of drafting to say these service credits represent a diminution in the value to the claimant, and they're not intended to be a compensation. And that then leaves open the fact that a claim can be made for damages on top of the service credits. Any other questions? We are reducing in numbers. I'm getting hungry. Are you getting hungry? I'm getting hungry too. I haven't had lunch yet. So any more questions? Just going to keep it open for a few seconds more. If there are no more questions, people leaving. Okay, that's great. I'm going to shut down in a few seconds. Just going to thank everyone for attending. Great that you could come. It's great to be back behind the helm. Really love it. And I'll be doing another one, hopefully towards the end, towards the beginning of next month or middle of next month or whenever it is. If anybody's got any ideas out there as to what you'd like me to talk about on a commercial law theme, very happy to get suggestions. If you want to get a copy of the slides, happy to share those with you. Other than that, I'm going to shut down now and wish you all very happy rest of your day, and speak soon. All the best. Take care. Bye-bye.